Hi, I'm Robert Pollock here at Fausone Bohn, LLP in Western Wayne County, Michigan. And I'm here to talk to you a little bit about condo associations and a condo association's duty of care. As you already might know, in June 24th, 2021, there was a devastating Miami condo collapse. This happened in Surfside, Florida, managed by Champlain Towers South Condominium Association. This was a tragedy, and our thoughts and prayers definitely go out to the victims and the families involved. Oftentimes, we like to blame condo associations for these types of things that happen in condos. Condo associations' bylaws usually lay out the maintenance duties of a unit owner and the condo. And condos usually, the associations have exclusive control over the common elements, which means that the condo association likewise has the duty to ensure the unit co-owner's safety involved in those areas. This duty of care is like a landlord. They have the duty to maintain the common elements and to use reasonable care in those areas. And that's breached if they don't perform like a reasonable association would perform in maintaining that area. In 2018, there was an engineering report created for the condo association involved in this Florida collapse, and it laid out a lot of issues that were pretty large issues, structural damage that was going to cost $9 million at the time in 2018, and ended up costing $15 million in 2021 when the association finally sort of took hold of the reins here. I won't bore you with the details of the construction report, but the association may or may not have breached their duty of care depending on the facts that are laid out and the facts that will continue to be laid out. The association was put on notice of this issue with 3 years prior, but the report did not say that the association needed to make these repairs in a certain time frame, or that the association would collapse if these repairs were not made. So there's a reasonable argument either way, but there's developing info that's coming out. The association definitely did try for a special assessment, and associations usually must maintain 10% of reserve funds in Michigan, which is a requirement for certain repairs and things. But like we saw in this case, often a special assessment is also needed in addition to reserve funds for certain big repairs like this. Generally, condominium associations usually have a mechanism for special assessments, which depends from condo association to condo association, and usually depends on the bylaws. Usually it's anywhere from 51% to 2/3 of a vote of the co-owners to approve, so it's generally hard to approve. And without approval, the association may not have had funds in this association to pay for these extensive repairs. New information's coming out that they had $700,000 from two years of reserve funds, which obviously wasn't enough to pay for the $15 million in repairs, so they needed to make a special assessment for that. And it was about $100,000 to maybe $200,000 a piece for each co-owner to make these repairs. So many of the co-owners may have just walked away and instead of paying that special assessment, just walked away. So the court will likely have to make a determination on what the association did and whether that was reasonable under the circumstances. And so what can we take away from this? Well, condo safety and maintenance is an extremely important and necessary thing. It's always very necessary also to hire the right management that can hedge some of these issues and cut them off at the start. It's also really important to act quickly on immediate dangers, even if it's something that they didn't say it was going to happen immediately. Well, be proactive. Take a proactive approach on your board in inspecting your common elements, making sure that everything is safe and ready for your co-owners to use. It's also important to maintain appropriate reserve funds to prevent the need for these large special assessments whenever possible. And it's important to review your condo docs and to ensure that your voting mechanism for special assessments is appropriate for your association. I'm Rob Pollock at Fausone Bohn, LLP. I thank you for watching. If you're a condo association and you have any questions on limited common elements or general common elements, or updating your docs or any general counsel issues, feel free to call us for assistance at 248-380-0000. And again, until next time, thanks for watching.